Good morning. This is the court clerk, Amanda Gaynor. Can I ask everybody to please start their video? I just want to ensure that all videos are working and we're prepared to go in about 5 minutes. Thank you, Mr. Thurman. Mr. Guanasso, thank you. Mr. Whitney, thank you. To the state, I have an attendee as ESD. Good morning. This is the court clerk, Amanda Gaynor. Can I ask everybody to please start the... My apologies. I just want to ask the state, I have an attendee listed as ESD Legal Counsel's Office. Is that a party that needs to come in?
No.
Okay, thank you. Okay, it looks like we'll be ready to go here in about 2 to 3 minutes. Thank you.
All right, good morning, everyone.
Good morning.
We're on the record in the case of Amethyst Payne and others versus State of Nevada. Case number civil 20-755. I'm Judge Breslow, presiding judge in Department 8 of Nevada's 2nd Judicial District Court. We are proceeding as we have with prior hearings in this matter through simultaneous audiovisual means as allowed by Nevada Supreme Court Rule, Subpart 9, and compelled by various administrative orders of Nevada's 2nd Judicial District Court on account of the global COVID-19 pandemic. I am conducting court today from my chambers here in the Washoe County Courthouse, 75 Court Street here in Reno. Ms. Gaynor, would you please identify yourself as the court clerk, as well as what county and state you're addressing the court from?
Thank you, Your Honor. Amanda Gaynor, court clerk, Washoe County, Nevada.
Thank you very much. The court certified shorthand reporter, Ms. Zinn.
Isolde Zinn, Washoe County, Nevada.
Excellent. Thank you very much. Counsel for plaintiff, starting with Ms. Jones.
Good morning, Your Honor. Leah Jones from Washoe County, Nevada.
Thank you. Mr. Thurman.
Mark Thurman for plaintiffs, Washoe County, Nevada.
Thank you very much. Mr. Ott, good morning.
Greg Ott, calling from Carson City, Nevada, joined by ESD counsel Troy Jordan, acting director Cafarata, and acting ESD administrator Jeff Frischman.
Very good. Mr. Whitney, good morning.
Good morning, Your Honor. Good morning, everyone. Robert Whitney, appearing today from Clark County, Nevada. Thank you.
Thank you. Ms. Cafarata, good morning. We haven't had you in one of these hearings before, but it's a pleasure to have you, and I look forward to having you involved in this matter. Okay, here's where we are. The court has received, a joint motion seeking to stay this matter for 30 days. The court's to understand the parties were to use that time to attempt a mediation that might resolve some or all of the issues in dispute. Since that was filed, I'm aware as well that there have been competing appeals of some of the determinations of the district court in a new appeal because the prior appeal was dismissed by the court. I'm also aware that there has been briefing on allocation of the special master's professional fees and costs. And by the way, I do note, Mr. Guanasso, I didn't mean to ignore you. I see you're here observing the proceedings. If you would please identify yourself for the record and the county and state you're calling in from.
Good morning, Your Honor. Thank you. Jason Guanasso reporting from Washoe County, Nevada.
Thank you very much. And so I'm aware there's been briefing as I've requested on the allocation of the special master's professional services expense, and I've reviewed and considered those. I'm aware as well that there has been filed as of yesterday, I believe, a motion to extend the time for plaintiffs to later seek an allocation of fees and costs for their professional services in this case. That motion itself has not been fully briefed or submitted, so the court is not intending to address that now. As well, of course, there was a prior renewed motion seeking this court's order holding the state in contempt for failing to completely abide by the court's prior writ of mandate, but by the joint motion to stay this case to allow mediation, the court understands that is stayed, that request for a contempt order is stayed. And so the court indicated as much with recent communications to both sides so that would not be heard. I also indicated that if the parties reached agreement as to payment of at least 50% of the special master's combined billings without prejudice for either side to seek reallocation thereafter, then this entire hearing would be postponed. But I didn't get a response to that that sufficiently convinced the court that an agreement had been reached. So this hearing remains on. Therefore, what I anticipate doing today, and then I'll canvass everyone to see if they are of the same belief as to the protocols as opposed to the substance, which we'll get to shortly. But the structure of this hearing this morning is to discuss the payment of the special master's professional services for the court to officially grant the joint motion to stay other aspects of this case pending opportunity to mediate, to acknowledge that this court is divested of jurisdiction on other than ancillary proceedings in light of the competing appeals, to recognize that there is a motion seeking an order to give plaintiffs more time to file their own request for fees and costs, but confirm that that's not yet before the court, and to confirm as well that we will set another hearing sometime in middle to late October to see what happened with respect to the mediation, and to see if a further hearing on the special master's fees and costs is needed, and to see if there is then a pending motion either on a motion for fees and costs by either side or a motion for additional time to file a motion for fees and costs. So there, I think I've hit all the high points. Let me start with Mr. Thierman and Ms. Jones. Is that what you understood this hearing this morning would be about at this juncture? Let's start with Mr. Thurman.
Yes, Your Honor, except that 54B order is kind of a combination, or at least one of a combination of things that are going on. And in order not to get into the issue of separating different theories and what's left from on the fees, we asked for the motion to to extend that until after the whole case is over. My understanding of the motion for attorney's fees, it's got to be 21 days within the order, and the order is about, I don't know, half a week old. So if I don't have an answer on my motion fairly soon, I gotta make it anyway in an excess of caution. That's all.
Well, you know, you have tools in your tool belt to seek this court, making a decision on the motion to defer having to file a fee motion soon. You can ask the court to shorten the state's time to respond and ask and have it submitted thereafter, or shorten the state's time to respond, file a reply and submit it thereafter. Or you can reach out to the state off the grid and ask them if they will, you know, stipulate to a shortened briefing schedule, or to stipulate to the merits of your motion. I mean, there's a lot of ways to approach it, but one way I'm not prepared to approach it now is to say on the record after some discussion that the motion's granted. It just got filed. I haven't reviewed it thoroughly, haven't considered it, and of course the state has a right to respond. But you've convinced the court that it's something that is a bit time sensitive, or at least I heard you, and I'll be on the lookout for anything that requires the court's immediate attention. Let's see.
Just that you said October, and October will have come and gone, and we will make a motion for shortening time.
Very good. All right. With respect to the other issues the court just addressed, did I miss anything? And I do want to comment that I have reviewed affidavits or declarations of indigence for the people that were filed on behalf of plaintiffs. So even though I didn't mention that in my preliminary comments, I do note that they have been filed. But anything else at this point, Mr. Thurman?
Not for me, Your Honor.
Ms. Jones, did the court overlook anything?
No, Your Honor. Thank you.
Okay. All right. Let's start with Mr. Ott. Is that what you understood this hearing would be about? In other words, is the state still asking the court to stay the remainder of the case other than the ancillary matters that the court has indicated it is prepared to go forward on?
Yes, Your Honor. The state stands by the joint motion was filed with plaintiffs.
All right. Thank you very much. Mr. Whitney, anything else?
No, Your Honor, just that, again, we stand by that joint motion that we filed with Attorney Thurman. Thank you.
All right. Well, then let's talk. Thank you. Then let's talk about the special master's billings. As the court understands the respective sides, there is no, and I want to talk about the combined billings at this point. If somebody says, hey, Judge, we did not have yet an opportunity to thoroughly vet the second monthly billing. We only spoke to the first month billing. You know, tell me that now, because if I don't hear comment to that effect, I'll assume we're ready to proceed as to both, at least with respect to the work done, the rate of compensation sought, and the cost expensed. Is there any objection, Mr. Thurman, to the court having a discussion about both billings at this time, or would you rather limit it only to the first one?
No, I have no objection to handling both.
Okay, either Mr. Ott or Mr. Whitney, your thoughts?
Your Honor, we can discuss both.
Both, all right. So thank you. So then the court understands that both sides recognize that the special master worked very hard. He and his staff provided a service to the court, to the people of Nevada, and also that the billing rate sought is fair and reasonable. In fact, the court notes the rate appears to be a rate lower than Mr. Guanasso normally charges for professional services. And then even with that, there was a discount applied at the end. And so that whatever discussion we'll have as to allocation, resources, requirement, ability to pay, we're not going to have a fight about the work done, the benefit conferred, and the rate charged. But if I've misunderstood that, tell me now. Let me start with this time with Mr. Ott or Mr. Whitney.
So I guess the only thing that I would slightly disagree with is I think our analysis was not necessarily that the fee was reasonable, but that the court has already ordered that fee. And so it wasn't a matter that was needed to be discussed. So I don't think we went so far as to declare it reasonable. We didn't do a lodestar analysis or anything to that event, but I think the court indicated that in its initial order. So that's the one, I guess, correction I would make or
right.
issue.
All right, thank you. I mean, I don't recall there being any particular protest as to the rate at the time the master was hired. And I'm assuming if there was concern that that rate was unreasonable in any way, I would have heard about it at that time. And we've all been proceeding under, the court's been proceeding under the assumption, as has the special master, that there was no material objection to the hourly rate to be applied for work done by his office. Mr. Whitney, do you know any different than that?
Thank you, Your Honor. No, I don't. Thank you.
All right, thank you. Mr. Thierman, your thoughts?
I think the rate is below market. Hours are documented. And there's no question about that. He did the work and he should get paid for it.
Okay, then let's move then to the analysis the court applies under Rule NRCP 53 G2. Generally, the court looks at three factors when allocating among parties in a disputed piece of litigation for the cost of the special master. The court, the three main prongs, as we're all aware, as suggested by that rule, and cases construing that rule, mostly from the federal courts, which have the essentially identical rule. The three factors are the nature and the amount of the controversy. The second factor is the respective parties' means, and the third factor is the extent to which any party is more responsible for the other for the reference to the master in the first place. And the court retains the right to order an interim allocation and to later adjust it or amend it as events may warrant. Now, as to that thought, the court is well aware that there are competing appeals and that are challenging some of the court's prior rulings in this case. And you have a different view, clearly, as to how we got to this point in time, what the dispute was about, whether it was bona fide, whether it was providently or improvidently brought. I'm well aware of that. But the three main factors the courts look at, the type of controversy, the amount of controversy, the respective parties' means and ability to pay the special master's professional expenses, and the extent to which one side or the other was responsible for the need for the master in the first place. All right, so with that, Mr. Thierman, what is the plaintiff's position, please, on how the court should construe those factors in this case? And are there any other factors the court should be considering in its analysis?
The special master is not a party, so and therefore, success on the merits, or actually even the amount of controversy, although this case is probably worth over $1 billion in total, is irrelevant. He did the work. Now it's a matter of allocation, and that's based, I think, on the needs or the abilities of the party to pay as much as anything. So no, I have nothing really to add except my clients are indigent.
Okay, thank you very much. Mr. Ott, your thoughts?
Thank you, Your Honor. Wanted to add one additional thing for the court's consideration. I could address it later. Is one of the things the court indicated in its order or its offer to postpone this hearing in the event that an agreement was reached was the time frame on which the special master could be paid. There are some administrative restrictions if my client is ordered to pay. There's some administrative restrictions about when we can get access to that money that I'd like to be heard on at some point. So just wanted to flag that for you. Okay. With regard to the three issues that you spoke about, the nature and the amount of the controversy, we briefed this, and I won't rehash everything in full detail, but I think one of the things that the cases speak to is public interest groups that are bringing suit, sort of on behalf of the environment to protect a public good. This is not that case. This is a case filed on behalf of private parties who are seeking compensation. They've already indicated that they're also going to seek substantial amount of fees. So I don't think that prong should be used to weigh against the state. This is a dispute between parties over money. So I think that's a neutral prong. With regard to the means, they filed declarations of indigency regarding the 12 named plaintiffs. They've also sought a class certification, which has not been granted yet. That I think goes first and foremost to the fact that any order this court should enter should be an interim order, because it's certainly different to allocate fees amongst parties when you have 12 plaintiffs who may not have means, as if you declare a class later on that has thousands of people. Certainly the cost could be shared rather easily amongst tens of thousands of people, even a substantial bill. So that I think is something that merits an interim order. But I think also the court is aware of the historic budget consequences that the state is under as well. So I don't think that the state should be considered as someone with substantial means, given the historic consequences of the financial crisis that we're in. And finally, the responsibility of the parties is the third prong that you addressed. And I think that is also where we look at how this case has been litigated. We have 12 named plaintiffs. There hasn't been a class certification yet. Plaintiffs have made very broad reaching claims about many plaintiffs who are not, or many parties or claimants who are not parties to this action. That expanded the special master's work immensely. If he had been assigned to work on just the 12 named parties, his report would have been much smaller, and I think he probably could have done it in a lot less time. But he was not. He was asked to work on a much broader topic, and that was the way that the plaintiffs have litigated this case. They have expanded it prior to seeking class certification in a way that ballooned the special master's bill. So I think when the court considers the responsibility for the fees of the special master, that weighs more heavily on the side of allocating fees to the plaintiffs than the state. So I think when you look at the factors in their totality, the first one is neutral. I think the second one is neutral but merits an interim allocation, and the third one bears in favor of allocating costs to the plaintiffs.
All right, thank you. I mean, before I turn back to Mr. Thierman or Ms. Jones, it's not lost on the court that in the Nevada Supreme Court order dismissing the appeal, the first appeal, in a footnote, it was observed by that court that there was yet no ordered class action. And so it had an effect on those reviewing this court's work, that the case status was what it was, and that the writ of mandate itself had a pretty broad scope in the light of the procedural posture of this case. Whether that is, in this court's estimation, determinative, important, or a fact that doesn't change the ultimate analysis here, is still something the court is considering. But I do want to hear Mr. Thierman's response, please, to what you just said, Mr. Ott, with respect to the fact that, this is a case that was brought by a small group of people, but we've treated it as though it's on behalf of a very, very large group of people. And that's the way the case has progressed for the last 3 months. And of course, before I ask Mr. Thierman for his comments, I want to observe something else. Early on in this procedural posture, the court inquired, whether this case, the court could order the type of relief sought without a formal request for certification under Rule 23. And there was discussion, and ultimately the plaintiff convinced the court that it was proper to go forward with this because of the nature of the harm sought being the type that was capable of repetition, yet evading review. And that at this point, no further determination of class certification need to be sought, much less granted. But we did all see what the Nevada Supreme Court observed in a footnote, and we do now hear, Mr. Thierman, the state's concern that the scope of the special master's work, and hence the professional fee sought, is a byproduct of allowing the scope of this what might have been a limited dispute to expand to statewide implications. So with that, Mr. Thurman, how would you respond to that, please?
Yes, the state's resuscitation of the third criteria contradicts its arguments on the first criteria. It says that the scope was really way too broad because it included basically 400,000 people who were not getting their unemployment properly. And yet it says, on the other hand, well, we shouldn't have had it that big because after all, it wasn't that big to begin with, which then they should have said, fine, they should have moved to limit it at the time that the special master was appointed. I'm not so sure that it's, when I use the terms B2 and B3, I realize that Nevada uses the letter C under Rule 23 instead of B for the same thing. So it's a B2 or a C2 or a C3 class action. It's not a monetary class action, it's injunctive relief. My assumption is if the state is told to do it for one, it will do it for all if they're identical. And I can make the motion during the 30 days for class certification, or I can wait till the end of this. But we've all proceeded under the theory that this is a systemic problem. It's a benefit to all the other people. And if the state really wants 400,000 individual cases filed, I'll gear up. I'll file in every court there is. That's not an effective use of the court's time or the Supreme Court's time, and we will get conflicting judgments and adjudications depending on the judge we draw. And so I suggest that the state's argument about whose fault this is kind of misdirected. They could have said, no, we're not going to do the special master. If this only involves 12 people, really only involves 2 people. But the state's failure to perform led to the increase in people. If the state, or if you want, we can amend in at least, I don't know, 4,000 or 5,000. I think it's better to seek certification, and we can do that during the interim period if the state wishes to modify the waiver it asks for, but whatever. I mean, I don't think those 2 factors count. In terms of the existence of the state to pay $64,000, if we can't pay $64,000, I don't know what they're going to do when they get hit with the bill for the UI portion of this, which they insist everybody belongs in. I think that's an absolutely absurd argument. If the state was doing its job, we wouldn't have this problem.
Okay, I understand your position. Mr. Ott, would you like to respond?
Yeah, first a clarification, different pots of money regarding the amount of money that's going to pay for unemployment and the money that would go to pay the special master's fees. There's grant funding that is not able to pay attorney's fees and of that sort. So the allegation that if we can't pay the special master's fees, then we're not going to be able to pay the unemployment. That's different. I don't want people to have the mistaken concern. They've already said that they will borrow to make sure the unemployment are getting paid. So want to make sure that's not an issue, and want to make sure that it's clear that we've filed a joint motion with plaintiffs to enter into a good faith mediation to try to resolve the case. Don't let any arguments that I'm making here regarding the allocation undercut that agreement. We intend to spend the next 30 days trying to find a resolution that works for everyone. That doesn't change the fact that under the prongs that have been set forth, we do believe the case has been expanded by the conduct of the plaintiffs, and we think that is a factor the court should consider. So I don't want plaintiffs' counsel to think that we're trying to re-escalate. We made a good faith commitment, and I intend to stand by it, but we also stand by the arguments regarding the allocation.
Okay, thank you. Here's the court's decision. While no formal request for class certification has been made, much yet briefed, submitted, and ruled upon by the court, all parties and the court have been proceeding with this case under the assumption, with the understanding, sometimes implicit or tacit, sometimes articulated and stated, that this court's determination of issues as to these people would have likely a localized and statewide effect on the manner in which benefits were sought, reviewed, determined, and paid or denied. The special master was appointed to assist the court in gathering facts to enable the court to properly analyze the evidence in this matter and come to fair and just determinations of contested issues. The appointment was done and the order entered thereafter consistent with that. There was no written objection to the appointment of the special master, and there has been no objection to, as the court understands, the quality of the effort or product of the special master and his staff, the timeliness, the conclusions. I mean, while there's a bit of a difference here and there on some of the ultimate factual observations made or the implications therefrom, the fact is that to the court's understanding, there is universal consensus that the effort made was extraordinary in a short period of time, and the result was informative to all involved on the direction of issues important to this case. So because of all those reasons, the court is prepared to go forward with a determination of the allocation of the special master's professional expense at this time. Before I go through each factor, though, I want to further observe there is a mediation to be had here. The court grants the motion to stay this case other than these ancillary proceedings for a minimum of 30 days. So before we end this call, we'll set a hearing for middle to late October to see where things stand. Also, the court recognizes, as I mentioned earlier, that jurisdiction is largely been divested of the court anyway by virtue of the cross appeals. The court believes it has authority to move forward at this time on things like allocating payment of the special master's fees and costs, any properly and timely submitted motion for fees and costs by either party, and absent the mutual or joint motion to stay, which I've now granted, the court believes it would otherwise have jurisdiction to hear and decide whether there's been compliance with the court's prior writ of mandate. Those, in the court's estimation, constitute the type of ancillary matters for which the court retains jurisdiction and is not divested by virtue of the appeal and the cross appeal. In allocating master's fees, I'll make this order. This, what the court will state now, applies only to the master's first monthly billing. I will defer a ruling on the second monthly billing until the status hearing we have in mid to late October. As to the first billing, the court has balanced the nature of the controversy here, the amounts at issue, both as pled and as implicitly litigated. The court has considered the parties' means. The court is acutely aware of the statewide budget crunch, but as well, the court is aware of the indigent nature of the named plaintiffs. The court has considered which party, as between both sets of parties here, is more responsible than the other for the reference to the master. The nature and amount of the controversy the court finds to be largely neutral, doesn't favor one side or the other. The parties' means the court finds militates toward directing that the state pay the special master's fees and costs, as well as the extent, factor three, the extent to which any party is more responsible than the other for the reference to the master. The court finds that that as well falls on the side of responsibility to the state. The court has already ruled that a writ of mandate should issue in part, at least on those buckets that the court ordered on. The court has now denied it as to the remainder, but the nature of the case, the types of relief sought, the ultimate award order by the court suggests to the court that the need for the court master here is more the responsibility of the state of Nevada than it is to these named plaintiffs. The court believes that federal jurisprudence is in line with this court's analysis. The Chevron Corp case from the Southern District of New York, the Morgan Hill Concerned Parents Association case from the Eastern District of California, among the two that have applied federal law, the federal rules of civil procedure, which in this case essentially mirror Nevada's rules of civil procedure. So on balance, the court finds that the equities favor the court's decision to impose upon the state of Nevada 100% of the billings, which the court finds inherently fair and reasonable, both in scope of work, work performed, billing rate for all professionals by the special master. So that full amount, as identified in the very first billing of the special master, the court orders the state of Nevada to pay. We'll talk in a minute, Mr. Rod, about when that could be done. I don't want to make an arbitrary amount of time, which you would advise the court administratively would be a near impossibility. But I do not want this to linger because Mr. Guanasso and his staff did this work and in the court's estimation, did it well, of assistance to the court, pursuant to a court order that was not objected to, and the court finds their work and their billings to be eminently reasonable. As to the second billing, the court will defer that to the next hearing, which will be a status hearing to see where things stand post-mediation and to discuss the billings with respect to the second month of the master's work. And any other pending matters that the court would retain ancillary jurisdiction over that are fully briefed and submitted. And again, I'm not limiting either side to asking for relief or review or consideration of any submitted motion before the date that we'll give you in October if the circumstances warrant that. But to the extent there are any pending matters, the court will address those at the hearing in October. With respect to the master's second billing, we'll discuss that in October. And with respect to how things stand post-mediation, we'll discuss that in October. And if need be, we will reset the hearing on the motion for order to show cause why the state should not be held in contempt. I'm not planning to have that hearing on the status hearing date. If we need to set a hearing on the renewed motion to hold the state in contempt, we will discuss that at the status hearing in October and likely set it for early to mid-November. Obviously, if the parties are successful in the mediation, well, then that moment in time never happens. That being the court's holding, Mr. Rott, I am aware that the state disagrees with the substance of the court's ruling. I understand and respect that, but nevertheless, that is the court's ruling. Administratively, what amount of time would the state need to bring current the special master's bill for professional services for the first month of their work?
Thank you, Your Honor. So under NRS 353-220, expenses of more than $30,000 need approval of the Interim Finance Committee and the Board of Examiners. The next Interim Finance Committee meeting is on October 22nd. The deadline for submission, my understanding, was passed. However, we have sought special extension of time to be able to put something on the agenda to the close of business tomorrow. So if the court can get out an order tomorrow, we should be able to be on the interim finance agenda on the 22nd. After that, the approval would need to go to the Board of Examiners, which my understanding is November 10 is the next one scheduled after October 22. There is a Board of Examiners on October 13, but my understanding at this point is that the IFC has to come first for the approval before the money is approved by the Board of Examiners. I'm told after the approval of both of those administrative steps, the check should be able to come out in 5 days, assuming that everything is approved by the various bodies. That is my understanding is we're probably looking at November 15, unless something happens out of our control to either speed up or slow down the process.
I'm going to try to measure my words here. So that the meaning of what I'm about to say comes across as respectfully and politely as I possibly can. I appreciate there are steps to go forward with when payments in excess of the amount 30,000 are being sought. I understand there's an administrative protocol. I understand that there are concerned, knowledgeable, informed people who make these determinations. But not in a disputed civil litigation matter where a court has ordered payment to be made. I'm not sure, Mr. Rott, that the protocol you just described to the court applies. I'm used to having complete and total compliance with the court's orders when ordered, and by the time the court gives the party or the person to comply, unless there's extremely good cause to vary from that. As I've done here, I asked for a realistic, I'm asking you for a realistic amount of time that the state would need to comply. Are you suggesting to the court the only way that the special master gets paid pursuant to a court order is for this payment request to go through the administrative steps that you've just identified? I mean, that would be a bit perplexing to this court, but nevertheless, if that's your position, I'll certainly take that into account. But I find that extremely difficult to believe that the state of Nevada would not comply with a court order directing a special master to be paid forthwith. What would you say, Mr. Ott?
Your Honor, I certainly understand the frustration. In my experience, having had orders for various fees in the past, those orders have gone before Board of Examiners and Interim Finance Committee prior to payment being made. I'm not aware of a way to circumvent the process of 353220. We can make requests to expedite the process to the Board of Examiners and to the Interim Finance Committee. Those individuals, we're obviously not in control of those individual schedules. We can certainly make efforts.
Sorry to interrupt, but I'm aware of the process you've identified, but that's if the state hires counsel, for example, to work for the state, outside counsel or another professional service provider, and they submit a bill. And the bill needs to be reviewed and considered, approved, and paid. Are you suggesting that the process you've just identified has been used before when there's been a court order? Because again, to me, there's a disconnect. Is that your position, Mr. Ott? And then I want to hear from Mr. Thierman.
Yes, Your Honor. And as a matter of fact, there was a recent order for fees levied against Detr on a public records case, went through exactly this process. It had to go to get approval through the necessary steps before it was paid. I don't believe that there was a time deadline on that order, but that was the order that was issued, and it was paid after those steps were satisfied.
Well, I said I'd give Mr. Thierman an opportunity to address the court, although really this is not something, now that the court has made a decision that the fees will be allocated to the state, he really should have a dog in this fight here. But Mr. Thierman, if you have any position that you can educate the court that you've seen before in other matters, I'll certainly give you an opportunity to share those.
I'll defer, Ms. Jones.
You're going to have to say that, please.
I'm sorry, Ms. Jones will address that, Your Honor.
Thank you, Ms. Jones.
I'm going to take your lead, Your Honor, and try to be very measured in my response and respectful to the court and to all the people that are working on this case. I would just hope what you just said about paying the special master who did do a lot of work and who is charging a rate well below market level. He deserves to get paid. All of us sitting here are still working. We can still pay our electricity bills. We can go to the grocery store. We're not being evicted. The people that we're talking about that are not getting paid, even after the court ordered the state to pay them, and I understand the contempt motion is not before the court, are wondering why the state and the court can put the special master, who is not, and I don't think this is a stretch, is not in jeopardy of being evicted. These people are getting more and more desperate. There are still people out there that should be paid, that have had payments stopped and that aren't being paid. So that is something that is going to mediation. And we have had multiple discussions with Mr. Ott and Mr. Whitney, and we are going in good faith to try and get people paid. That is the number one issue here, is to get the average Nevada citizen paid. It's quite frustrating that we spent more time discussing the special master's fees than we're discussing getting people paid. Now, I understand that this was not what this particular hearing was for, but again, it's plaintiff's counsel's position that yes, the special master absolutely should get paid, both the first part of his fees and the second part of his fees. If plaintiff's counsel had not bought this civil rights lawsuit, it's a civil rights lawsuit. it is unlikely we would be sitting here and there would be even more people in desperate situation. Detr has had a revolving door of employees because they can't seem to get it right. All we're asking is that Detr gets it right and gets people paid. If we understand that the state has different budgets, where different buckets to be paid, it is up to the court to decide when is acceptable for the special master to get paid. But again, we would just hope that the same reasoning that you just applied to the state for the special master's fees would be applied to all the people, all the Nevada citizens that are in jeopardy of losing their homes, have lost their homes, have lost their cars, have had to give up their children, and are wondering what they're going to do for another 30 days. Thank you.
Thank you. All right, Mr. Ott. I wasn't anticipating that type of discussion at this point, because I want to keep the as heartfelt or genuine as the emotions are from both sides here. I'm trying to keep this train on the track, and right now the track is the court is encouraged that mediation is on the table. The court is encouraged that the parties are talking. The court is encouraged that both sides recognize the value that Mr. Guanasso as special master and his team added to this matter, and the excellent efforts to educate the court on an area that the court was relatively new in becoming involved in. But let's get back to the issue that I want to have some closure on. Again, you've told the court that even in other matters where fee orders are entered by other courts, in your experience, the process still takes the approximate 60 days from the court order through the process, consistent with the statute, to when payment is issued to the provider of services that's been ordered to be paid. Is that your position, Mr. Ott?
Yes, Your Honor. And I rely on 353-220 subsection 4 to say that, you know, once you are above that $30,000 threshold, those procedural restrictions kick in.
Your Honor.
Yes.
It seems to me that, yes, there's this procedure, but the procedure goes to a board that after this court order is lacks discretion to do anything but do as this court order. I mean, throughout this whole litigation, that's the dichotomy between what the court says needs to be done and what we think the law says needs to be done. And Detr says, well, no, I'm going to follow my procedures. Now, I don't know in particular whether 60 days is going to be a major problem for Mr. Guanasso, but I think that in terms of the mentality, and I'm not thinking the council, I'm thinking the rank and file, the court order is a court order, and it takes precedence over anything and everything else. So, you know, I don't think these people have discretion not to pay it. So do it as quickly as possible. I mean, what would happen if the board said, no, we're not going to pay it? I assume this court would order contempt.
The court orders that payment be made to the special master for representing the first request for fees and costs on or before November 15th, 2020. Now, when we have our status hearing, we'll talk about as I mentioned, the second piece of the fees and costs. And then we'll decide what to do with respect to that portion of the special master's professional service expense at that time. The rest of this case is stayed, as I've stated. I'll now give you a hearing date for a follow-up hearing along the lines of what the court has previously identified. Ms. Clerk, let's look for a time, please, somewhere before Halloween, please.
You have the afternoon of October 20th available. That's a Tuesday.
Okay, let me ask counsel to please check their calendars.
That seems good for plaintiff's counsel.
Thank you. Mr. Ott, Mr. Whitney?
Thank you, Your Honor. That's good for me.
All right, thank you.
We can make
Mr.
that
Ott?
work. October 22 p.m.
Yes, October 20th, 2 o'clock in the afternoon. And again, if there are other matters that need the court's attention before then, make sure they're submitted, and we'll keep an eye out for anything. Now, I guess that's it at this point. Mr. Thierman, anything else that the court may have overlooked? Ms. Jones, anything else?
No, Your Honor.
All right, thank you. Mr. Ott or Mr. Whitney?
The only wrinkle is hoping that we can get a court order by tomorrow to get it on to start the process.
I'll have it filed before the end of the day tomorrow.
Thank you, Your Honor.
You're welcome. Mr. Whitney, anything else?
No, Your Honor. Thank you. I can't think of anything else. Thank you.
You're quite welcome. All right, I want to thank everybody for their time this morning. A pleasant afternoon, and we'll see you in October, if not sooner. Have a nice afternoon. The court will be in recess.
Thank you, Your Honor.
Thank you.
Thank you.